नमस्कार, आदाब, सत श्री अकाल दोस्तों। स्वागत है आपका एक बार फिर से हमारे YouTube चैनल ब्रास फ्यूजन्स पर, जहां आज हम आपके लिए लेकर आए हैं एक नया लेसन।
Okay, now what I've done is I've actually had to remove him. So if he comes back in again in the ask and you just tell me and I'll let him in. Okay, I couldn't mute his mic, so I had to. I'm sorry, I had to remove him from class. But if he tries to come back, I'll let him in again. Okay? Yeah. I don't know. When I pressed mute, it removed him. I don't know. Maybe there's some problem that I did. I'm not sure. Anyway, let me go back. So now it's described as a constitutional power, and in response to your question, Priyanka, if I were to take the view that the constitutional power is an amalgam of all powers, I don't think that it would quite work, because he's certainly not exercising any appellate judicial function. Therefore, I would prefer to treat it as part of the executive power, notwithstanding the description in Kehar Singh that it's a constituent power. I think what they meant in that is that it is an old power that continues in order to do full justice in a particular case. The idea being that the judicial power is exercising a legal function. When the judge convicts a person, he looks at the facts, applies the law, and comes up with a conviction. And in criminal law, the judge is bound to apply the criminal law, notwithstanding the fact that under Article 142, the Supreme Court has the unique power to do complete justice in a particular case. Yet, if the evidence is very clear towards the culpability of the person, they will have to convict. You cannot ignore the culpability in order of the name of doing complete justice. To clarify my point, if there is a hungry person who steals a loaf of bread, we know the motive was to assuage his hunger or that of his family. Yet in law, the intention was clearly there to steal the piece of bread. And in first year, you have studied the distinction between intention and motive. And for bringing any offense into play as defined in the IPC, we look merely at intention, we don't look at motive. Therefore, motive is not seen as a ground for removing culpability of the person. Intention था क्या bread चुराने का? हाँ. Then give the punishment. However, in exercising the pardoning power, the president is able to look at more matters than the court could look as a court of law, because the court is a court of law, right? Notwithstanding the fact that in 142 they have the power to do complete justice, but in criminal law matters they will have to define and convict the person based on the definition of an offense, which in this case is based on intention, not motive. And a second procedural ground which limits the verdict coming from the judicial branch is that they are also bound by the rules of evidence. And under the rules of evidence, the foremost rule is the rule against hearsay. You will only allow that which is relevant and that which is admissible. So many pieces of evidence may be relevant yet are not admissible. किसी दूसरे ने इसके बोला, मैंने सुना. It may be relevant, but non-admissible because of the rule against hearsay. So, the woman who committed the crime was pregnant, or she was, whatever, some other grounds may be there, which you may not be able to look at. However, the president in exercise of pardoning power is able to look at these, and that is the reason why it's clearly not a judicial function. He is not part of the judicial hierarchy. Yet to treat it, it's easier in our minds if we were to treat it as a constitutional power, but partaking of the qualities of executive power, because he is bound by the aid and advice of the Council of Ministers on this point. So what I'm now going to do in order to understand this even further and to answer a few more questions, how does the president exercise his power? True. But the point is that if I Priyanka, let me just say this. I don't want to go on this point. Constitutional power has elements of judicial nature in it, but to treat the exercise of pardoning power as a part of the judicial function will end up creating one more appellate structure in the hierarchy. And therefore, while we can loosely call it as a constitutional power, but it does not partake of any judicial quality in it. And one of the greatest reasons is that there is no compulsion for the president to give a right of hearing to the person who asks for a pardon, whereas no judge can decide a case without giving a hearing to the accused party. All hearings have to be in open court, usually unless there are specific in-camera rules, whereas pardon petitions are heard completely in private. They don't need to even hear the accused person. So procedurally, in terms of substance, there are so many changes that to say that it partakes of any of the quality of judicial nature, I think would not be correct. And that's why we all study it as part of the executive functions. Okay. Now, in order to just clarify this point, how does the president exercise the power? Should he give a hearing? Can there be judicial review over the president's exercise or non-exercise of powers? We're going to look quickly at two cases. First case I'm going to take up is Kehar Singh. But before I begin Kehar Singh, let me in passing tell me, you studied K.M. Nanavati in first year? K.M. Nanavati, the film Rustam, etc. What was the final conviction of the Supreme Court in K.M. Nanavati's case? What was the conviction and punishment imposed upon K.M. Nanavati? Khawaz Nanavati, for murdering that lover of his wife, Sylvie. Murder is the offense. Punishment kya tha? Guilty 302. Punishment.
Imprisonment, ma'am. Life.
What punishment?
Life imprisonment.
Life imprisonment. Good. So punishment always has to be with sentence, not conviction for the offense, right? Life imprisonment. And then he got his pardon from whom?
Governor of Mumbai.
Governor of Mumbai. And did he get pardon, remission, respite? What did he get?
Pardon.
He got a pardon, wiped clean. I didn't know. I went to Wikipedia, I have to tell you the truth, to look at this. And I found that he had gone back to his wife and they went away to Canada, I believe. I just read a Wikipedia entry on that. I didn't know that.
Yeah.
Okay. Yeah. Because in that film, Rustam also, he goes back to his wife, right? Akshay Kumar.
That part has not been shown in the movie.
That part was not shown in the movie. Yes, it was not shown. But they show the fact of him going back to his wife. Yeah, that's it.
Yes, ma'am.
Yeah. Okay. So now come to Kehar Singh. So I want the two students who've prepared this case in 5 minutes to tell us who has prepared for Kehar Singh, please. Who has prepared? Who are the two students who are prepared for Kehar Singh? Okay, since nobody is prepared, let me take it up. Now look, I would suggest you read the Kehar Singh. I've posted it in our classroom site. For those who are not in the classroom, I request somebody to just post the link of Kehar Singh and Maruram in the chat box so that other students can also benefit. Also post the project 39A of NLUD that I've posted, because it's a very useful site that I want students to look at. Please post all the 3 links that I've posted in the classroom, somebody. Okay. Now, in Kehar Singh, there are 2 Supreme Court judgments, and that Supreme Court judgment, which is of August 1988, I'm going to take up first, but the actual pardon one is of December 1988. Okay, so there's Kehar Singh 1, Kehar Singh 2. Let me take up Kehar Singh 1 because it will make it clearer about... post it from my box, please, from my classroom, because I want all 3. Kehar Singh, Maruram, and then Project 39A of NLUD. I want all 3. Thank you. Now, Kehar Singh, This is dealing with Indira Gandhi assassination on 31st December 1984. The actual people who gunned down Indira Gandhi that morning when she was walking from her home to her office, was Satwant Singh and Beyant Singh. And Satwant Singh and Beyant Singh was taken away by the ITBP and by evening, by the time the FIR was lodged, actually Beyant Singh was dead. I'm not going into the question of what happened, but he was no more after that. Yet Satwant Singh was present there, and he was charged with actually gunning down Indira Gandhi. And that trial went very smoothly because there were eyewitnesses. It was from his AK-47 that the assassination happened, and he was sentenced to death, and the pardon petition was rejected and he was sentenced to death. That's with Satwant Singh. Yet, there was two other players in the game. One was Balbir Singh and the second was Kehar Singh. I'm going to leave out the story of Balbir Singh now. If you read the first Kehar Singh judgment and you read the judgment of Justice Oza of the Supreme Court speaking for the three judges, it will give you the story of Balbir Singh. But now I'm on Kehar Singh. Kehar Singh was not present on 31st December 1984. He was picked up later in the afternoon. Yet, the offense against Kehar Singh and also Balbir Singh, let me not take up time about Mr. Balbir Singh, Kehar Singh, was the conviction played out because of Section 10 of Indian Evidence Act. And since we're students of law, let me just tell you the story because I think there's lots of learnings in it and revision in it. Section 10 Indian Evidence Act. Section 10 Indian Evidence Act, what is it?
Conspiracy and evidence.
Which is the case you studied in first year or second year, whenever you study evidence. Have you studied evidence? Mirza Akbar's case?
Mirza Akbar, Emperor versus Emperor.
Yeah. The lead case on it. And you know that if one is a part of the conspiracy, all that one needs for conspiracy under Section 120B is you neither have to do actus reus, nor do you need to have had the intention of committing that specific offense. It is sufficient if you are part of the conspiracy. If you are part of the conspiracy, then whatever Mr. Satwant Singh was doing, you had the mens rea, he did the actus reus of gunning down Madam Indira Gandhi, then whoever is part of the conspiracy will get charged and be convicted for the same offense, even if he was not present. And in Kehar Singh's case, that is really how he was convicted for 302 and also convicted for capital sentence, for death sentence. Is not present. And that shows you the power of conspiracy and Section 10 of the Indian Evidence Act as read together with 120B of the Indian Penal Code. It's one of those offenses where just being a member of a criminal conspiracy will make you liable for all the actions that any member of the conspiracy ever did. So if there are 10 people and only one of them goes and murders, all the other 9 will also be guilty. And how does that happen? Section 10 of the Indian Evidence Act makes every piece of evidence which is against that one person who committed the murder both relevant and admissible against each of the others. So it is much more than, in one sense, Section 34, 49, 120 is standing on completely another pedestal. Fine. Now, Kehar Singh, of course, when you read the judgment, is supposed to have radicalized both Satwant Singh and Beyant Singh. And after Operation Blue Star, he, saw signals, as it were, for him to take action, and therefore he was charged with conviction under 302 and death sentence. So that is the August judgment. And if you read the August judgment, which is the first cohort, Kehar Singh, what I've put down in the classroom is the second one. I've not put down the first. You can just locate it and read it. It is a fine judgment dealing with section 10 and 120. So if you want to quickly look at 110 and 120, you should read Kehar Singh 1. And as students of law and as a political history of Kehar Singh, at that time there was a broad sort of campaign also that this is a miscarriage of justice to read conspiracy in this manner, etc., etc. So you should read that first judgment because it's part of Indian legal and political history. I'm not talking about Kehar Singh 1, which is concerned with conspiracy and section 10. When Kehar Singh was in death row, he was in death row in the sense that he was awaiting his death sentence. A pardon petition was filed by his son to the President of India. Before I proceed, let me just deal with one other matter. We have had cases, Vaitishwaran versus State, Triveni Ben versus State, Sher Singh versus State are three important court judgments of the Supreme Court around the same period of the 80s, where the question arose whether a person who is in death row awaiting the death sentence, if a person is kept waiting for death sentence for 2 years, this is a fit case for commutation from death row to life imprisonment. And the fact that the president kept it pending for 2 years, in Vaitishwaran, the Supreme Court took the view that 2 years keeping a man waiting, he doesn't know ki kal mein marunga, parso mein marunga, is so cruel that a person who's kept waiting for 2 years should be automatically commuted to life. Supreme Court in Vaitishwaran. In Sher Singh, they said, no, we don't want to put any hard and fast rule. It depends on the facts and circumstances in the case. But eventually, in Triveni Ben, the Supreme Court refused to say that they would automatically suggest commutation. They said this is something for the court to decide. And therefore, the law as it stands now is, if a person is kept in death row, meaning awaiting death sentence, and the mercy petition is pending for whatever reason for too long without disposition either positively or negatively, you could move a petition saying it is too long, 2 years, there's no now specific cap or time limit, and then you will have to try your luck in court whether this should be commuted or not. So that's a little side story. That little side story does not come into effect in Kehar Singh because he was convicted in August, and by December, his commutation, his death sentence was fixed. And as we know, it was disposed of and the hanging did carry out. So it was hardly long enough, but I just thought I'll let you know this little story. Now, when the petition was pending, he was, I think he was, if you read the judgment, I'm forgetting a little bit about dates, either on 30th or 29th November, he was informed that the hanging will be carried out in the next 2 or 3 days. So immediately his son moved the petition. It's like the Yaqub Menon's case, right? Same way. And he asked, it was disposed of. He moved yet another mercy petition saying, I must be given a personal hearing because I will explain that while I had discussions with Satwan Singh and Bian Singh, remember I told you that they were all friends, and though I felt agitated, I was in no way responsible for Satwan Singh and Bian Singh gunning down Madam Indira Gandhi, and therefore treating me as part of this conspiracy was wrong. I may have shared some views with them, but I was certainly not part of the criminal conspiracy. Please give me a personal hearing in order that I can clarify it to them. Now, for demanding this personal hearing is how the petition then gets filed, and Kehar Singh too comes up before the Supreme Court. And in the course of Supreme Court, as a preliminary point, the first question that arises is the Supreme Court competent to scrutinize the manner in which the president is dealing with such a mercy petition. A, is there judicial review at all? And what the Supreme Court in 1988 does is it relies on this great judgment in Maru Ram versus Union of India, which is a judgment delivered in 1980 on 11th November 1980. I'll tell you why I'm telling you the date. It's probably the last judgment that Justice Krishna Iyer wrote for a 5-judge bench before his retirement on 15th November 1980, when he retired when he turned 65. And this is a great judgment that is worth reading. And Maru Ram tells you two things. Maru Ram tells you that the exercise of mercy petition is under the aid and advice of the government. And then it also tells you that notwithstanding the fact that president exercises this constitutional power to give mercy and to give pardon and to give clemency, yet this is a constitutional power, and it's in that context they were talking about. And because it is a constitutional power, it cannot be above scrutiny by the courts. There is judicial review, but a very limited judicial review. Because it's a constitutional power, it cannot fly above the Constitution. And in the Constitution, doctrine of checks and balances tells you whoever exercises any power should be exercised within the power and should not exercise it for bad reasons, what we call mala fide reasons, and should not be exercised on irrelevant considerations. So in the Maru Ram case, for the first time, it was acknowledged that it was a constitutional power. So it's in that sense that they call it constitutional power, not a sovereign power which is above. Be you ever so high, the law is above you, which is the rule of law principle. It's not a sovereign power where the king was above all law. And therefore, there is a limited role of judicial review. We are not looking at why did he give pardon, why didn't he give pardon. That would be a scrutiny looking at the merits and looking at the facts of the case. No. The only thing that the courts will look at is to find, is this a case where he could exercise pardon power? Maybe it was some other kind of matter. Is it within his powers? And number two, is it mala fide or bona fide? Is it exercise that I'm pardoning him because wo mera bhaiya hai, isliye main pardon kar rahi hu? No. It should not be exercised mala fide. And thirdly, it should not be exercised for irrelevant considerations. Wo mere chacha hai, isliye main pardon kar raha hu. It's both mala fide and for.
दोस्तों, अगर आपको आज का लेसन पसंद आया हो तो वीडियो को लाइक करें। इसी के साथ अगर आपने अभी तक हमारा चैनल सब्सक्राइब नहीं किया है तो सब्सक्राइब के बटन पर क्लिक करिए और बेल आइकन दबाना ना भूलें, ताकि आपको एजुकेशन से रिलेटेड नए नए अपडेट्स मिलते रहें। और अधिक जानकारी पाने के लिए आप हमारे फेसबुक और इंस्टाग्राम पेज से भी जुड़ सकते हैं, जिसका लिंक डिस्क्रिप्शन बॉक्स में दिया गया है। धन्यवाद।